Contesting a will. Will's variation. If your spouse or parent died, disinheriting you or leaving you with an inadequate, unfair, or unjust inheritance, you can have a right in British Columbia to contest their estate by commencing an action for will's variation pursuant to Section 60 of the Wills, Estates and Succession Act. BC is unique in Canada in that it, along with Nova Scotia, are the only provinces that have wills variation law that allows adult, independent children to contest a will on that basis. The rest of the provinces only have dependents relief legislation, which provides that you need to be not only a spouse or child, but also financially dependent on the will maker to have standing to bring a claim. In the Supreme Court of Canada case called Tatterin versus Tatterin, the court found that a deceased person owes legal and moral obligations to a spouse and moral obligations to their children. Legal obligations are measured as if you had a notional separation with the deceased just prior to their death, and you look at the relevant division of family property under family law legislation, the Family Law Act. Moral obligations are measured regarding the quality and length of the relationship, and factors including whether you contributed to the will maker's estate or provided unpaid services and caregiving, whether you had a legitimate expectation to an inheritance, whether there was any estrangement, whether you committed any misconduct against the deceased, or your financial need in the circumstances. Each case will be examined on its facts, and the court has a lot of discretion to determine if a will should be varied in favor of the claimant. You have 180 days from grant of probate to bring a will's variation action, so don't delay if you want to pursue your claim. Get in touch with us today, and we will be happy to assist you make a claim. Our lawyers are highly experienced at attaining great results for our clients.